Hello, I'm Julia, Associate Director of the Nuffield Family Justice Observatory. Welcome to this lunchtime talk. Today we'll be hearing from His Honour Judge Chris Simmonds, the Designated Family Judge for Dorset, and Her Honour Judge Gaynor Lloyd, the Designated Family Judge for North Wales. Over the past year, family courts in Bournemouth and Weymouth, Caernarfon, Mold, Prestatyn and Wrexham in North Wales have been trialling an investigative and problem-solving approach to private law proceedings, with a particular focus on improving the court's response to those who've been affected by domestic abuse and having a greater focus on the voice of the child and hearing that effectively. The changes include Cafcass and Cafcass Cymru, gathering more in-depth information at an early stage, including speaking to the child before first hearing in most cases. There's also a focus on better integration of services outside of the court with the court system, including those specialising in domestic abuse and mediation, to provide a better response to families. So today, Judge Simmonds and Judge Lloyd will be explaining a bit more about those pilots, including the background to the model and some of the successes and challenges they've had so far. But first, I'd like to say a few words about this event. There are about 300 of you joining today, and although we can't see you, we would like to hear from you. So we've already received a lot of questions. Thank you very much to everyone who sent one in. But please do use the chat tab to share any others you have or any comments or reflections on what you're hearing. If you prefer to listen to the event without the potential distraction from the chat, do feel free to disable it by unchecking the Show Chat Preview box in the chat tab on Zoom and keeping the chat window closed. While we will try and address as many questions as we possibly can during this event, we may not get around to all of them as it is only 30 minutes, but all questions will be read by members of the Nuffield Family Justice Observatory team, helping to shape future research and events. If you'd like to revisit today's event, then a recording will be available on the events section of our website, which is nuffieldfjo.org.uk, and you'll also find recordings of previous lunchtimes events there. I'd now like to welcome Judge Simmonds and Judge Lloyd. Thank you both for joining us.
Hello.
Thank you.
Well, can I start by asking, Judge Lloyd, can you explain a bit about the background to this model and how it came to be operating in Dorset and North Wales?
Yes, it arises from the recommendations of the private law working group, which was then chaired by Justice Stephen Cobb. And there were a number of commission pieces of work and reports that fed into the recommendations that led to the Pathfinder courts, including the Cascade Scoping Report in August 2020, the Family Solutions Group report in November 2020, and a central piece being the Harm Report, June 2020. And then the final Private Law Working Group report in November 2020 made the recommendations to set up a problem-solving court. And we're trying to marry the principle of trying to encourage out-of-court negotiated settlements, but also incorporating the findings of the Harm Report. The government incorporated or accepted the recommendations of the Harm Report as part of its manifesto commitment, and also here in Wales, the Pathfinder forms part of the work programme for the Welsh Government. So in a nutshell, that's the thinking behind it. It's a unanimous approach. There seems to be a high level of agreement. It led to Practice Direction 36Z, which suspends the operation of the Child Arrangements Programme in North Wales and in Dorset, and it allows us, I think it's an 18-month period now, where it's replaced with the Pathfinder process.
Thanks very much for that great introduction, Judge Lloyd. Judge Simmonds, could I ask you to explain then a few of the key differences between this model and standard private law proceedings under the Child Arrangement Programme?
Yeah, of course. The standard programme would have a safeguarding letter within 3 to 4 weeks. We'd come to a FHEDRA with that limited information. We'd then usually adjourn for a report or for some statements. And so we build in delay and the information we're going to get at the earliest possible stage. And of course, coming to court is a core part of that model. For us, it's very different. It's very much an investigative approach, with Cafcass being at the absolute core of that. We have an early gatekeeping where we look at the information, we speak, the court speaks to the parties at the beginning within days to say, look, this is what's going to happen and this is what's happening with your application. We front load the engagement, so that's Cafcass going out in the main, or the local authority, if the local authority are working with a family, identifying what cases have issues of domestic abuse, signposting those to the right services, risk assessing and drawing that risk to me or to our attention if we need to, engaging early on with the children. We're engaging in at least 70% of cases with the children directly, and avoiding coming to court. But if you are coming to court, we're going to make sure we've got the right information. So when we gatekeep at the first hearing, we identify what the issues are and what the problems are. It's done by a legal advisor. Cafcass then, in their child impact report, will investigate what the welfare issues are and if there are any alarm bells that need to be drawn to our attention. By looking at the case really early on, we're able to decide, well, actually, is it safe for this family to engage in out-of-court dispute resolution? We're staying about 5% of our cases for that, so adopting what was said in Re-K. So the difference is, if you're coming to court, we've got the right information early on to make the right decisions. And in fact, we will try our best to avoid you coming to court, because if it's been investigated properly and there are no safety issues, either the parties have reached agreement and we're able to deal with the matter with you never coming to court, or alternatively, when you come to court, that one hearing is the final hearing. And in the most serious cases, when you come to court, we can make the right decision about whether you need to have a fact-finding hearing or something else. So that's the main difference, having the right information early on and front-loading.
Really helpful to hear. I can see that we've already had some comments in the chat about a voice of the child, and Judge Lloyd has said in the introduction that one of the things that this model is meant to do is to enhance the court's ability to hear the voice of the child. And I wonder if you could just tell us a little bit more about how that's working in practice.
Three aspects really. The first is, as Chris said, the front loading. So that the typical model we've got in North Wales is that the author of the CIR report will speak to both parents, then speak to the child or children, and then feedback to the parents what the children are saying. And that often leads to a reframing or a climb down in some cases, and the Cafcass officer will give the parents a heads up on what the likely recommendation is going to be. We're finding that leads to a much higher settlement rate. So it's front loading the voice of the child and making it central to proceedings. I mean, we've tried very hard to change the language of the court, so it's very non-adversarial. The only the core consistent message is we look at the impact of adult behaviours and whatever the vulnerabilities in the families are, and the impact of that on children. And that's been a really powerful way of getting parents to stop focusing at each other and looking at the children. The other two ways is the CIR report specifically deals with whether the children wish to participate in proceedings, meet the judge, express their views in any particular way. And then we're also doing a piece of work at the moment on how we can improve giving the results to children. It's not as simple as it is in public law to meet a child, because there isn't always a suitable person to bring the child to court. But those are the key ways. We are also getting feedback from children who are receiving services from the IDFA services and domestic abuse services, and that's often a good way for children to communicate their wishes and feelings as well. So lots of work on the voice of the child, and that's really central to this core model.
Thanks very much for that, Judge Lloyd. Just picking up a bit on what you were talking about there in respect of IDFA services, if I could ask you, Judge Simmonds, as I understand it, one of the core elements of the model is about the better integration of the court with the support services around it. And so I wondered if you could tell us a bit about what that's involved and how you feel that integration is working in the two Pathfinder areas.
One thing you have to do with Pathfinder is get out of your silo, and that means going out and meeting lots more people and the services that are there, and not just knowing about them, but actually speaking to them regularly, and I speak to domestic charities in our area regularly. I know the workers, I know what they're doing. So dealing with domestic abuse first, I have never seen so many domestic abuse workers in my court, and that's well before the practice direction. We have a standing rule that they're allowed in unless there's a very good reason, and I've never had an objection to it. So that's been a real change, and one that I have found refreshing and a real supporter of. Domestic abuse workers feel able to come to court and they really support the most vulnerable. That's happening, of course, because at the very beginning, we are referring people to services. That's part of the initial assessments that Cafcass do, dash assessments get sent out for it to be done. So domestic abuse workers are in the courtroom now on a very regular basis, and that is really important. Mediation services are being engaged with. If I'm being really honest, when an application came in, we would go through standard directions, but we weren't really drilling down at the earliest possible opportunity. Are there safety issues here? Have MIAMs been claimed appropriately? Should these parties have a little window to go out and see if they can reach agreement without the need of the court? And did they know that there's a voucher available? So we're doing that at the beginning. I said earlier, 5% of cases we're saying for parties to go and reach agreement because the court isn't the best place. And of course, at the earliest opportunity, when parties are being engaged with by Cafcass, I mean, we send them out a lot of information that's easy read about services that they can engage with. But at the earliest opportunity, when the child impact report author is meeting with the parents and talking to them about their child and focusing them very much in to their welfare of their child, they're signposting them to different services. And in Dorset, we have a number of hubs run by Dorset Council, so they can signpost them there for services. So are we seeing better integration? Yes. Am I coming out of my silo? Yes. But actually, the domestic abuse charities, the hubs, the child impact report workers, mediation, they're coming out of theirs. And in fact, we're working together because we know each other and we've broken down a great many barriers.
That's really encouraging to hear. Judge Lloyd, thinking then about domestic abuse survivors in particular, because as you've said, the harm panel was a significant part of the thinking in the development of this model. Have you had any feedback directly from domestic abuse survivors, so adults or children, about how this model has worked for them?
Yes, it's anecdotal at the moment, but we have a dash risk assessment in all cases that needed. And we have found a significant number of cases where both parties are asking for domestic abuse support. So we've seen a huge number, as Chris said, a big increase in adverse coming to support people at court. We're finding that's really helpful in getting parties to focus on the issues. And yes, the main theme that we're getting feedback from domestic abuse survivors is that this process, it's much less brutal and much less unkind than their perception of adversarial family law proceedings. They feel supported, and that support deliberately goes on way beyond the scope of proceedings, and the signposting that we undertake for people again goes way beyond proceedings. And we also encourage people that if they fall out again, that they look at out of court services to try and resolve their problems rather than coming to court. But yes, we're finding that direct involvement, certainly in North Wales, I think we're probably up to nearly 100 families that should have been accessing the adverse services that weren't, and they are now getting support. So there are a lot of families out there falling between the cracks at the moment. So it's had a really positive impact. That's certainly the feedback we're getting.
I can just follow up on that, Judge Lloyd, in respect of the domestic abuse services. I think we've had some questions in the chat about how the risk assessment process around domestic abuse works. Who's doing that risk assessment? How does that feed into the overall analysis being provided to the court? Could you just give us a little bit more information about that?
In North Wales, any initial safeguarding process that raises issues around domestic abuse, we will make a referral to there's two main IDVA services in North Wales, Dasu and Gorwel, depending on geographically which location you're in. We have an agreement with them that they turn around what's called a DASH assessment. We had a lot of discussion about whether DASH was the best tool. It's a standardized tool, but that's the model that the whole committee and everybody agreed on in the end. So a DASH assessment will take a couple of days, and if there is a referral for both parents in North Wales, those assessments will be completed within 7 days. Then the summary of the DASH assessment is then appended to the CIR report and feeds into the conclusions of the CIR report, and then that family can or cannot remain open to the IDVA services. Many people prefer not to engage with domestic abuse services on an ongoing basis, particularly if they have had a traumatic past, preferring not to identify as victims at the moment, but the offer is there for people and the services are clearly signposted. So that happens very early on, usually between week 2 and 3. So by week 3, we will have a clear indicator. And then if there's serious issues raised in the risk assessment, you'll quite often then find a 16A finding its way back to court for the urgent attention of the judge. So we've seen an increase in 16A reports and been able to manage issues of risk much, much quicker.
And just in relation to that, when the model was being set up, was there any specific training around domestic abuse which formed part of how the model was being implemented across the various services?
There was a real multidisciplinary approach to it. So yes, there has been training, and we certainly in North Wales, we had a day-long workshop where we invited all of the IDVAs to come, all of the judges, all of Cafcass social services, and that was incredibly illuminating. So I would really encourage anybody, any of the judges who are on the call to engage with the local services, because it really enhances your understanding of assessing risk and just an understanding that people don't often want to spell out what the risk issues are, what the vulnerabilities are. It's not as simple as lawyers think of just putting it down in black and white. It's been a really interesting process, but a really valuable one. I think it's seen, and I know we're coming to core successes in a moment, but it's seen as a real core success here. It's bringing protection and a serious evaluation of risk right into the heart of what we do.
And then I promise I'll finish this topic in a second, but I think there was a question in the chat earlier about what happens in situations where judges don't want to have IDVAs in court. And I think Judge Simmonds said that that's not something that's happened in Dorset.
I mean, the practice direction is now very clear. You have to have very good reason. And I must say, I have always struggled to find a good reason. I can find no good reason why you wouldn't allow an IDVA into court. I don't know.
Is that the same? Has that been the same experience in North Wales, Judge Lloyd?
I'm not aware of any case where we've refused an IDVA in court. I'd be very surprised if there were any.
Brilliant. Judge Simmonds, then, could I ask a bit more? We've heard a bit about the anecdotal feedback, as Judge Lloyd described it, from domestic abuse survivors, but what other evidence has been gathered so far about this pilot, and what are the greater plans for evaluation? Particularly, are there plans to include interviews with parents and children about their experiences?
All right. Well, Judge Lloyd and I know that we are told all the time, anecdotes don't cut the mustard. That's our we're told that by Mrs. Justice Knowles on a very regular basis, and she's absolutely right. We need the data, and we are collecting the data. We collect this at different levels. We collect it on a local court level. So my court manager this morning tells me, how many cases are coming in, how many cases are coming out, what our timeliness is of them, and we can see what's going on. But the MOJ are doing it, and the MOJ are conducting a deep dive evaluation. As a judge, I have to complete a form after each hearing saying what happened, what support services were offered and why. That the court collects data at each and every stage, and that data is being collected by them. We've had a draft initial reports that we're able to go through. I know there's a report coming out at some stage, and I'm not the expert on that, but Rachel at the MOJ will know. And of course, we're having lots of visitors. We're having people actually coming and probing what we are doing, whether it's at minister level, whether it's Nuffield, whether it's Professor Hunter with the harm report hat on, whether it's colleagues. And so it's being looked at in an analytical fashion by the MOJ, but by outsiders coming in and actually seeing what we're doing and poking it. And more importantly, they're speaking to our providers. So they're speaking to Cafcass, they're speaking to the domestic abuse charities that are working with family. They're seeing cases about what is going on, and that will all feed in eventually to the evaluation. And I think the evaluation is going to include speaking to people, but I'm not on the ball on that one.
Thanks very much. I think we've had some questions in the chat about the practice direction under which this pilot is proceeding. So could you just explain if there is a specific practice direction, and if so, where people might find it?
For you, it's practice direction 36 Z. It's available to all. You can just download it, and it's a really simple read, actually, and it goes through each and every one of the stages. And you can tell I keep it on my desk at all stages. It's all got lots of things highlighted in it. But it's a simple read, and it's well worth reading because it gives you the stages that we're going there, the gatekeeping stage, what you expect from a child impact report, what we should be doing at gatekeeping 2, or we call them triage, what a determination hearing is. So it's a really good practice direction. And we've also got some standard orders that we use. So we've tweaked and changed as we've gone along, and there's a very close relationship, working relationship between us here and North Wales. So we're always sharing information to try and improve things.
Thank you very much for that. Judge Lloyd, then, can I ask you to have a think across the whole model and think about any particular successes you feel that there have been within the model so far?
I mean, it's impossible to do this in 2 minutes. That's a really cruel question. Well, what I can say to you is that it's universally popular here with all of us who are involved in the system. In terms of successes, I'd say it's kinder, much less brutal for everybody, whether you're a victim or a perpetrator or just somebody who is going through the unhappy process of separating. It's much less traumatic for people. Relevant issues are identified early, they're grappled with early. People will know that in England and Wales under the CAP system, it's an average of week 44 before a Rule 16.4 guardian is appointed. Here we're appointing them in week 7 at gatekeeping. So there's a huge difference in identifying those issues, identifying how serious the issues are and what resource should be allocated. We're using case progression officers. They are brilliant, a really good asset. The participants love hearing from a case progression officer. They answer questions and alleviate a lot of the stress pre and post proceedings. We've already touched on the IDFAs. That's been a brilliant, much more formulaic inclusion in the process. That works really well. A huge success for us has been gatekeeping 2. So we've taken all of that initial case management out of busy district judges and legal advisors, court lists, dealing with them here and there with the stress of that. They do gatekeeping on allocated days, sitting back to back. They don't have any hearings. It's a brilliant use of resource and far, far more productive than trying to spread it out across court lists. So the gatekeepers will do up to 6 cases each and give really robust and full directions and a very clear steer to the receiving judge how they are to deal with a case. That's led to consistency. That's the next big win, I'd say. Much more consistent responses. What we've done in North Wales is we allocate cases to 2 tracks. So we have the case management track, which are the most complex cases, which are brought in for directions in week 9, following gatekeeping in every case at week 7. And then the less complicated cases that just need a resolution and need one hearing are allocated to the adjudication track, and they get a final hearing within 10 weeks of issue. So, I mean, those figures speak for themselves. Speed is a huge advantage. No child has ever benefited from court delays. So the speed is brilliant, and everybody gives us positive feedback. They would rather have a decision, any decision, than lots and lots of adjourned hearings and dithering about in a system that doesn't really support any of them. Less hearings, 50% go on the adjudication track, and they get one hearing. And then we're finding on average between 2 and 3 hearings for the more complicated cases. We have far less 12J finding of fact hearings. We identify vulnerability much quicker. And because we're focusing on the issue and problem solving, we're finding that the fact finding hearings are not really useful unless you've got a really, really stuck case where there are real fundamental principles involved. And we're finding now, certainly North Wales, a year in, we're freed up a lot of court times because the cases are finishing a lot quicker. We are even, I'm probably won't be thanked for saying this, but we're even in a position where having to cancel magistrates' courts because there isn't work, because things are, so many more cases are resolving. And in terms of delays, you used to in North Wales have to wait 10 to 12 weeks for a final hearing slot in front of magistrates. Now you wait 2. Similarly, the DJs, we are managing to list things within our targets, which is within 12 weeks of issue. So it's freed up a lot of judicial resource, and it's also had some benefits for Cafcass. Whilst it's painful to front load the work for Cafcass, they are not having to do long Section 7 reports, and we rarely, if ever, trouble Cafcass with any additional pieces of work. Sorry, I could talk for half an hour just about the successes, but there's lots of them, and I'm happy to talk further about any of those issues at any point.
No, it's lovely to hear so much enthusiasm for something happening in the family courts. It's not always the case. And so I'll give Judge Simmonds the slightly harder task of talking about what have been the challenges, if any, of implementing this new way of working.
One word: resource. I took over as DFJ when this was being launched. We were down by 50% of our judges. We had limited legal advisors, which remained to be the same. And we had problems in our court staff. You know, we had vacancies that hadn't been filled. So our case progression officer was doing everything. We had to take legal advisors to do gatekeeping from out of area, and they've been outstanding, Leanne and Tom. I'm really grateful to them. Yet with all of those problems, we were able to make Pathfinder work. We had a huge backlog of legacy cases created by the fact that we just didn't have judges and court time. But towards the end of last year, we were making real inroads in them. And I've got no 2018, 2019 cases left. And I've got a spreadsheet with the ones from 220 onwards that are legacy. And as judges, we are working through and we're giving them priority. We've got court time to do that. We didn't have it before Pathfinder. So that's a real improvement. And we were able to look at the cases and say, actually, we were dealing with those incorrectly. So limited judicial resource, limited court staff aren't a bar to making Pathfinder work. What it meant is when I got some more judges in January, my evenings and weekends became a little lighter, and they weren't tied up doing a lot of this. Cafcass are the linchpin, as are the local authority resource. We've been able to get resource about domestic abuse workers. I'm really grateful to them. They've been excellent. So it's then looking at that other resource. Local authorities have been good. They've come on board, and again, they're able to turn the reports around in a quick period of time. And so resource is the biggest issue. And once that resource issue becomes problematic, Pathfinder loses what it's there to do. Because when you look at the practice direction and you distill it, an investigative approach, early intervention, front-loading engagement with the parties, and they're all the things that Gaynor has been speaking about, and I certainly know in Wales is very much on board with. So resource makes it is the biggest problem that we face, and of course that builds in, doesn't it, to what the harm panel said in 2020 about recognising and responding at the earliest possible opportunity, taking early steps to identify domestic abuse and managing risk, multi-agency working. And it's that we need to really concentrate. So what's the hardest thing? It hasn't been implementing this policy. It hasn't been judicial time. I'm like Gaynor, actually, we're starting to see gaps, which is really good for other cases. It's really about making sure that all the resource necessary is in place.
Thank you very much. And we're just coming up to 1:30, but I'm just going to ask Judge Lloyd very quickly, because I know this is an issue many people have asked about. Do you know whether these pilots would be rolled out nationally, and if so, when?
I don't. That's way above our pay grade. It's where we're being evaluated and scrutinised within an inch of our lives at the moment. So there does seem to be a lot of appetite for it, both from the Justice Department and also the Welsh Government for us here in Wales. We are the Pathfinder, so we are the pre-pilot. So because this was completely new, the whole point was that we would pivot and try different things in order to formulate a good product for the upcoming pilot sites. I know they were hoping to roll it out to about half a dozen pilot sites, including much greater urban areas, but I can't answer if that's good. Not as far as I'm aware, or when that would happen, I don't know. But hopefully, yes, because I would encourage and urge this on anybody. It's brilliant.
Thank you very much for that, Judge Lloyd. Well, I'm afraid that's all the questions we have time for. Thank you all so much for attending. And of course, thank you to Judge Simmonds and Judge Lloyd for joining us today. If you'd like to find out more about the Nuffield Family Justice Observatory's work, then please do visit our website at nuffieldfjo.org.uk, and you can sign up there to receive our regular bulletins, which contain information about upcoming research and upcoming events, and that's at nuffieldfjo.org.uk/subscribe. If you are interested in private law proceedings, can I take this opportunity to plug a really interesting new report published this week, authored by Dr. Linda Custworth, Claire Hargreaves and their team at the Family Justice Data Partnership, about the other 10% of private law cases. That's cases that involve people other than parents. It's shining a light on some really interesting issues for this often forgotten group, and I'd really recommend it to you. That can be found on our website, and I think there's a link in the chat. And finally, we would be really grateful if you could fill in the event feedback form. We really do use that feedback to inform how we structure and plan future events and what we think about including in our future calendar. So please do fill that out, and we look forward to welcoming you to more events in the future. Thanks very much.
Thank you.
Thank you.